All right, of the 7 expungement petition reasons that you can file, the first one is juvenile adjudication. Just a really quick discussion of language here at the beginning of juvenile adjudications. Juvenile charges are crimes brought against people that are under the age of 18. Because you're under the age of 18, you're prosecuted under the Juvenile Act. The Juvenile Act does not want to use the same language in prosecuting children that it uses in prosecuting adults. So whereas an adult would be charged with a crime, a juvenile is charged with an offense which, if proven against an adult, would constitute the crime of. I kid you not. There's a dance. If an adult were being convicted of a crime, the juvenile is adjudicated delinquent of the crime. It's the same as a conviction, but it's a juvenile adjudication. The trial would happen for an adult. A juvenile adjudication hearing is held for a juvenile. So anyway, juvenile charges against someone under the age of 18 are governed by the Juvenile Act. And the Juvenile Act basically says there's some ins and outs and some nuts and bolts and some details that if you're over the age of 21 and you've been out of trouble for 5 years, that you can petition the court to have your juvenile adjudication expunged. This usually happens because a juvenile adjudication for a serious felony, whether it's robbery, aggravated assault, kidnapping, things of that sort, if it's a felony 2 or felony 1, even if it's a juvenile adjudication, it's going to show up on an FBI background check and a Pennsylvania check for employment. So most juvenile cases don't show up for background checks, but felony 2s and felony 1s do. And so that's when somebody comes and says, hey, can you get rid of this juvenile adjudication? Also note, let's say you got charged with a crime when you're 16 or 17, and now you're 22 and you're trying to get employment and you want to file an adjudication. Let's say it was an aggravated assault where someone bled or you did some time in a juvenile facility. The district attorney, remember how they get a copy of the petition? They're always going to check with the victim. They're going to check with the Office of the Victim Advocate, and the victim might say, well, no, I don't agree with that. Now, the victim's opinion doesn't control what happens, but it's going to be taken into consideration. The district attorney might say, this is where a Wexler hearing might be appropriate. A district attorney might in effect say, Judge, I want you to schedule a hearing. And at the hearing, the defense would say, Judge, here we are. It's been more than 5 years. There's been no offenses since then. Here is Tom. He's going to college. He's studying. He's working hard. He needs this off his record so he can go on with his life and increase his earning capacity. And the district attorney might say, well, that's nice, but this crime is especially nasty, and someone was wounded, and they still bear the scars to this day. And this isn't a case where we think the judge should issue an adjudication. So this gets into what's called the Wexler balancing test. The judge sits there in the middle of the seesaw with the district attorney saying serious crime was only 5 or 6 years ago, so that's what the law considers actually relatively recent. And the defense attorney and the defendant say, but Judge, I've learned a lot. I'm now employed. Maybe I'm married. Maybe I even have a child I'm trying to provide for. This is bearing an undue hardship to me. And so that's what the purpose of a Wexler hearing is to give the judge the seesaw or the scale of justice for the judge to make the decision. Technically, when the judge makes the decision, the district attorney would be able to take an appeal if they really didn't like the decision. I don't think they normally would, but again, it all depends on the case. It's important to remember that 90%, maybe 95% of juvenile adjudications are routine criminal trespass, burglaries, stealing PlayStations, simple assaults, disorderly conducts, things that happen in school all the time. They're not these exceptional cases where someone bled or has a scar. I just have to give that as sort of an extreme example of when a district attorney might oppose an expungement petition. So to circle back, a juvenile adjudication can have a juvenile expungement petition filed on it after 5 years of law-abiding conduct if the person's over the age of 18, depending on what the district attorney's position is. And again, the defense and the district attorney would be trading phone calls and emails and talking about things ahead of time to try to work this out. An interesting side note is the fact that it's almost more difficult for a defense attorney to get juvenile records than for the juvenile to get them themselves. So sometimes, depending on the county where the adjudication is, especially if the person still lives there, I'll ask them if they can go to the juvenile record division and ask for a copy of their juvenile records so they can forward them to me. Then I can review them and give them good advice about whether we should file the petition, whether I think we're going to have a hearing or not, and quote a fair fee for whatever's going to happen. Some counties we actually can enter our appearance to represent the juvenile and request the records, but juvenile records is an especially sticky area of record requesting, and that's what I have to say about that.